Hey everyone, welcome to the Deep Dive.
Yeah.
We're going to be taking a deep dive into eviction notices in California. This one's for you. We know you're a tenant rights attorney at the Martinez Law Center, so we thought we'd pull together a bunch of different guides, FAQs, even some marketing materials, all about California eviction law, and kind of break them down. What we really want to zero in on is those 3-day, 30-day, 60-day notices. You know the ones.
Yeah, having a really good grasp on California's eviction laws is so important when you're advocating for tenants.
Okay, let's get started. First up, the lease agreement. Everyone's heard of them, but how many of us actually read them cover to cover?
The lease is like the foundation, isn't it, for the whole landlord-tenant relationship. And legally, it's a binding contract, and it's really important to know that. Both the tenant and the landlord have, obligations under that agreement.
Yeah, it's like the rule book.
As we can see from the sources.
There's a whole tenancy. And one of the most important things it covers is the tenant's obligation to pay rent.
Oh, for sure. And when rent isn't paid on time, that's when we start seeing those eviction notices come into play. That 3-day notice to pay rent or quit, that's a really critical one. In California, it's often the first step in the whole eviction process.
Okay, so let's break down the different types of notices that we have here in California. We've got the 3-day, the 30-day, and the 60-day notices. When is each one used?
Okay, so that 3-day notice, like we mentioned, typically for unpaid rent, but it can also be used for some pretty serious lease violations, like if a tenant is damaging the property or engaging in illegal activities.
And then for those month-to-month leases, that's where we see the 30-day and the 60-day notices, right?
Exactly. 30-day notice, generally for tenancies that are less than a year. And the 60-day notice is for tenants who've been in their unit for a year or more. One thing I think is really important to emphasize is that all these timelines are based on calendar days, not business days.
Oh, so if a 30-day notice is served on like a Friday, Saturday and Sunday still count towards the total.
Absolutely. Another point that sometimes people get confused about is that the day the notice is served doesn't actually count. So if a tenant is served on a Monday day, one of the notice period is actually Tuesday.
Okay, so those timelines are super important. And what if the deadline falls on like a weekend or a holiday?
Good question. In those cases, the deadline is just pushed to the next business day. The system really does try to, give tenants a fair chance.
Yeah, to respond. So let's circle back to that 3-day notice. We talked about pay or quit. What are the tenants' options when they receive this notice?
Well, the most straightforward way to stop the eviction process is to pay the rent in full within those 3 days. But, tenants can also try to negotiate with the landlord, maybe work out a payment plan or, see if there's some other way to resolve the issue.
And what happens if they just ignore that 3-day notice?
Ignoring the notice doesn't make it go away. In fact, it can really limit the tenant's options down the line. I think it's crucial to emphasize. For a 3-day notice to pay rent or quit to be valid, it has to state the exact amount of rent that is owed. If that amount is wrong, it's considered invalid.
Okay, so those notices are serious business. And speaking of serious business, let's talk about how those notices are actually delivered. Does the landlord have to follow specific rules?
Absolutely. California law is very specific about this. You can't just send a text or an email, stick a note on the door or something like that. You have to follow procedure. And all of the sources that we have really highlight this.
So let's say they just tape it to the door. Or they leave it in the mailbox. Is that good enough?
No, not at all. Those kinds of informal delivery methods don't really hold up legally. There are 3 main ways a landlord can legally serve an eviction notice.
Okay, let's hear them.
The first one is personal service. That's the most direct method. It means physically handing that notice to the tenant.
Okay, makes sense. What's the second?
The second is called substituted service. This is when the landlord can't personally give the notice to the tenant. So they leave it with a responsible adult at the tenant's residence, but they also have to mail a copy to the tenant.
It's like a double check to make sure they get it. Okay, and the third way?
The third way is posting and mailing. This is used when the landlord can't personally deliver the notice or find someone to accept it on the tenant's behalf so they can post the notice in a really visible spot on the property, like the front door. But again, just like with substituted service, they also have to mail a copy to the tenant.
So no matter what the tenant needs to receive a physical copy of that notice in the mail.
That's right. It's all about making sure that the tenant has been properly notified and having that paper trail to prove it.
Okay, so we've got the notices, we've got the timelines, we've got the delivery methods. Now let's say a notice has been served correctly. What happens next? Walk us through that typical eviction timeline.
Okay, imagine you're a tenant. You've just been served with an eviction notice. The clock is ticking. But it's important to remember that you do have a right to respond no matter what type of notice it is.
Hold on. What does respond mean in this context? Does it mean you have to move out right away?
Not necessarily. Responding means you have options. You don't have to pack up and leave. If it's a pay or quit notice, you could pay the rent. You could try to negotiate with the landlord, or you could even fight the eviction in court.
So there's a chance to make your case before you're actually evicted.
Absolutely. If the tenant doesn't comply with the notice within that time frame, the landlord can file an unlawful detainer lawsuit, which is the formal legal process for evicting someone in California.
Unlawful detainer?
It can be intimidating.
Yeah.
Once that lawsuit is filed, the case goes to court. The tenant will receive court papers and has 5 days to respond in writing. Super important not to miss that deadline.
So 5 days to respond, and then what happens?
Then the court will schedule a hearing. That's where the tenant gets to present their side of the story, argue their case, and potentially stop the eviction.
So they could try to prove that they did pay rent, or maybe point out that the landlord didn't follow the proper procedure.
Exactly. Raise any legal defenses that they might have. The judge will hear both sides and make a decision.
And if the judge rules in favor of the landlord,
Then the tenant will be ordered to leave the property. And if they still refuse to leave, the landlord will be issued a writ of possession, which basically gives the sheriff the authority to remove the tenant and their belongings from the property.
so it's not a simple matter of the landlord just kicking someone out. There's a whole legal process involved. Law enforcement might have to get involved.
Exactly. This whole system helps protect both sides, prevents landlords from taking the law into their own hands, and it ensures that tenants have a fair chance to defend themselves before being evicted.
Okay, so we've talked about timelines and procedures and the role of the court. But let's not forget about the tenant's rights in all of this. What are those key rights that you want our listener to be aware of?
This is so important. California is considered a very tenant-friendly state, meaning that the law has a lot of protections in place to prevent unfair or illegal evictions.
So give us some examples. What are some of those key protections?
Well, we already talked about how the eviction process itself has to be legal and proper. Landlords have to follow those strict rules for notices and timelines. If they mess up even one little detail, it could invalidate the whole eviction.
Okay, so following procedure. What else?
Tenants also have the right to a defense against retaliatory evictions. Let's say a tenant complains about a necessary repair or requests a reasonable accommodation. The landlord can't just turn around and try to evict them for exercising their rights.
So it's like a shield to protect tenants who are trying to assert their rights. What other rights should tenants be aware of?
Another important one is protection against illegal lockouts. Landlords cannot, under any circumstances, lock a tenant out of their unit without a court order. They can't change the locks or remove the tenant's belongings or shut off essential utilities like water or electricity.
Wow, so even if a tenant is behind on rent, the landlord can't just resort to those kinds of tactics.
Exactly. It's considered a serious violation of the tenant's rights.
Okay, so we've covered a lot of ground here. Notices, timelines, procedures, and some of those fundamental tenant rights. Now, are there any special cases or exceptions to these rules that our listeners should be aware of?
That's a great question. There are a few kind of unique situations where those standard eviction rules might not apply. One example is a 5-day notice, which can be used for certain types of serious criminal activity on the property.
So we're not talking about like noise complaints here.
Yeah.
Or minor disturbances. We're talking more serious offenses.
Right. Things that pose a real threat to the safety and well-being of other tenants or the property itself. Drug dealing, violence, other serious criminal offenses.
Okay. And in those cases, the landlord can move more quickly to evict the tenant.
Exactly. The 5-day notice gives the tenant 5 days to stop that illegal activity. And if they don't, the landlord can then proceed with the eviction process.
So it's like a faster track for situations that require, swifter response. Are there any other exceptions we should know about?
Another one that comes up sometimes is the 3-day unconditional quit notice.
Unconditional quit.
This notice is used in a very specific situation when a property is sold and the new owner wants to occupy the unit themselves right away. They don't have to provide a reason or wait for a lease to expire. They can simply issue this 3-day notice, and the tenant has to be out.
Wow, that sounds pretty tough on the tenant. So if you're renting and the property gets sold, you could potentially be out on the street very quickly.
Potentially, yes. Definitely something to be aware of.
So it seems like there are a lot of twists and turns in the world of California evictions. Always a good idea to proceed with caution and seek expert advice when needed.
I would agree.
All right, so we've done this deep dive into these different types of notices, the timelines involved, proper service procedures, even some of those special cases. Now, as a tenant rights attorney, What are some of the key takeaways you would want our listener to really focus on?
Well, understanding those different types of notices is absolutely foundational, knowing when each one applies, the specific timelines involved, and the options that tenants have for responding. That's knowledge that every tenant rights advocate needs.
It's like having a roadmap to navigate this whole legal territory. What else stands out as really important?
Proper service. Landlords have to follow the rules, period. If they don't, that can be a huge win for the tenant. Knowing how to spot improper service, and you know how to use that to your client's advantage, that's essential.
It's almost like a legal checklist. If the landlord misses a step, the eviction might not be valid. What else would you say is crucial for our listener to keep in mind?
The tenant's right to respond and to fight back is so important. Just because a landlord serves a notice, it's not game over. Tenants have options. They can negotiate. They can go to court. They have the right to make their case.
It's about empowering those tenants,
Yeah.
making sure they know they have options.
What else would you emphasize?
Understanding that eviction timeline is key. Knowing how long a tenant has to respond at each stage. How to file an answer to an unlawful detainer lawsuit. What to expect at a court hearing. All that is essential for effective advocacy.
So it's not just about knowing the laws, it's about understanding the process. What else would you highlight?
Another key point. Tenants have rights throughout that entire eviction process. Landlords can't harass them. They can't retaliate against them or use illegal tactics like changing the locks or shutting off utilities. Those actions have legal consequences.
So it's a two-way street. The landlord might be the one initiating the eviction, but they still have to follow the rules. And tenants have rights that they can assert every step of the way. Exactly. It's a legal process that's designed to ensure fairness and to protect the rights of both sides.
This has been so insightful. We've really unpacked a lot of the complexities of California eviction law and highlighted those essential things that our listener needs to know to be an effective tenant rights advocate.
Absolutely. And to build on what we've talked about so far, I think it's also important to touch on a topic that can be a real point of contention: security deposits.
Yes, the security deposit is always kind of lurking in the background. Of these eviction cases, what do we need to know about how security deposits work in California?
Well, a security deposit is money that the tenant pays up front. It's meant to protect the landlord against any damage to the property or unpaid rent. But California has very specific rules about how those security deposits can be handled.
So it's not just a free-for-all for the landlord.
Not at all. They can't just keep the entire deposit without justification. California law is very clear. Landlords can only deduct from the security deposit for specific reasons, like unpaid rent or damages that go beyond normal wear and tear.
Okay, but what exactly qualifies as normal wear and tear? It seems like that could be a bit subjective.
It is a great question, and it's often a point of disagreement between landlords and tenants. Normal wear and tear really refers to the kind of deterioration that happens over time just from living in a property.
So like scuffed floors, faded paint.
Exactly. Even if the tenant has been reasonably careful, you would expect to see some wear and tear over time. And landlords can't deduct from the security deposit for that. They can only deduct for damages that are clearly the tenant's fault. Things like broken windows, holes in the walls, or stains on the carpet that can't be cleaned.
Okay, so let's say a tenant moves out
Yeah.
and the landlord wants to make some deductions from that security deposit. What's the proper procedure?
California requires landlords to provide a very specific itemized statement of any deductions they're making.
So no vague claims like cleaning fees or repair costs.
Right. They need to list each deduction separately with a clear explanation of what the damage was and how much it cost to repair. And they have to send this statement to the tenant's last known address within 21 days after the tenant moves out.
So what if the tenant looks at that statement
Yeah.
and disagrees with the deductions? What can they do?
They have the right to dispute those deductions. They can send the landlord a letter explaining why they disagree and request a refund of the disputed amount.
And if the landlord refuses to budge,
Then it might end up in small claims court. So that battle over the security deposit could continue even after the tenant has moved out.
oh wow. That's why it's so important to document everything. Take pictures of the unit's condition when you move out. Keep good records.
Excellent advice. And remember, there are limits on how much a landlord can charge for a security deposit in the first place. In California, the maximum is generally twice the monthly rent for an unfurnished unit and 3 times the monthly rent for a furnished unit.
So landlords can't just demand an outrageous sum.
Not at all. The law protects tenants from those excessive security deposits.
Okay, so we've covered the basics of security deposits, those limits, permissible deductions. the dispute process. What else do we need to know about protecting tenants' rights in these eviction cases?
Well, one issue that can be a real nightmare for tenants is illegal lockouts. This is a tactic that some landlords might try to use to force tenants out, but it's completely illegal in California.
So just to be clear for our listener, what is an illegal lockout?
It's basically when a landlord tries to remove a tenant from their unit without going through the proper legal process.
So no court order, no eviction notice?
Exactly. They might change the locks, remove the tenant's belongings, even shut off essential utilities like water or electricity, all in an attempt to force the tenant out.
And that's all illegal, even if the tenant is behind on rent?
That's right. California law is very clear. Landlords cannot use these kinds of self-help tactics to evict tenants. It's a serious violation of their rights.
So what are the consequences for landlords who do this?
They can face some pretty significant legal and financial repercussions. The tenant could sue them for damages, which could include things like the cost of temporary housing, lost wages, even emotional distress.
So it's not just about, getting back into the apartment. It's about holding the landlord accountable.
Exactly. And on top of those actual damages, California law also allows for something called statutory damages in illegal lockout cases.
What are statutory damages?
It means that the court can award the tenant a fixed amount of money. Even if they can't prove that they suffered any specific financial losses, it's a way to punish the landlord and to deter them from engaging in these illegal practices.
It's like a message from the court. Don't even think about trying this again.
Exactly. And for tenants, if you ever face this situation, document everything. Take pictures, keep records, and reach out to a tenants' rights organization or attorney right away.
Okay, so those illegal lockouts are a big red flag.
Yeah.
Are there any other kind of sneaky tactics that landlords might try to pull?
Unfortunately, yes. Some landlords try to get creative and disguise their illegal actions. One common tactic is claiming that they need to make repairs to the unit and that the tenant needs to move out temporarily.
But if it's really just a scheme to get the tenant out, that's still illegal.
Absolutely. The landlord needs a legitimate reason to make those repairs, and they have to follow the correct procedures, including providing written notice and a reasonable timeline.
So if a tenant receives a notice about repairs, it's important to look at it carefully.
Definitely. Don't just take their word for it. Check the lease agreement, look for any inconsistencies, and don't be afraid to ask questions and get clarification.
What are some other tactics tenants need to watch out for?
Another common one is harassment.
What kind of harassment?
It could involve things like constantly entering the unit without proper notice, making excessive noise, or even threatening the tenant verbally or in writing.
Essentially making the living situation so awful that the tenant feels forced to leave.
Exactly. It's a sneaky form of eviction, often called constructive eviction, but it's still illegal in California.
So if a landlord is engaging in this kind of behavior, the tenant doesn't just have to put up with it.
Not at all. They have rights and they can fight back. Again, it's crucial to document everything, dates, times, specific incidents. That evidence could be crucial if you need to take legal action.
Okay, documentation is key. Anything else our listeners should keep in mind when it comes to these kinds of situations?
It's important to remember that you're not alone. There are organizations and attorneys out there who can help you fight back against these illegal practices. If you're facing harassment from your landlord, reach out for support and guidance. You have the right to live in peace and dignity in your own home.
That's a powerful message. Now, speaking of tenant rights, you mentioned retaliatory evictions earlier. Let's dive a little deeper into that. What exactly does that mean? And how does it play out in real life?
Retaliatory eviction is when a landlord tries to evict a tenant as punishment for that tenant asserting their rights.
So let's say a tenant complains about a needed repair, or requests a reasonable accommodation, or even joins a tenants union. The landlord can't just turn around and try to evict them for that.
Exactly. California law is very clear. Landlords are prohibited from retaliating against tenants who exercise their legal rights.
So it's like a safety net for tenants, ensuring that they can speak up and advocate for themselves without fear of losing their homes.
Exactly. It empowers tenants to assert their rights without fear of reprisal.
Now, what are some common actions that might trigger a retaliatory eviction? What should tenants be watching out for?
Well, as you mentioned, complaining about a repair issue is a big one. If a tenant requests a repair and then suddenly receives an eviction notice, it's essential to consider the timing and see if there's a connection.
So look for patterns. Ask, is this really about a lease violation? Or is this payback for speaking up?
Exactly. Another action that could trigger retaliation is joining a tenants union. or organizing with other tenants to advocate for better living conditions.
So landlords can't punish tenants for exercising their right to free speech and assembly.
That's right. Tenants have the right to come together and advocate for their collective interests.
And if a landlord tries to retaliate against them for doing so, they could face consequences.
Absolutely. Retaliatory evictions are taken very seriously in California. Landlords who engage in this kind of behavior could face significant penalties.
Okay, tenants. It's so important to know your rights. You have the right to complain about issues, the right to organize, and the right to live free from retaliation. What should a tenant do if they believe they're being targeted with a retaliatory eviction?
Don't hesitate to seek legal help. There are resources available to help you fight back and protect your rights.
Okay, so we've talked about illegal lockouts and retaliatory evictions, two big things landlords can't do. But what about the flip side? What are some things landlords are required to provide? Let's talk about the tenant's right to habitable housing.
Yes, this is a fundamental right that every tenant in California is entitled to. It means that the rental unit has to meet certain basic standards of health and safety.
So what does that mean in practical terms? What kind of standards are we talking about?
Well, the unit needs to be structurally sound, free from any major defects, and have working utilities.
So no leaky roofs, no broken windows, no faulty wiring.
Exactly. It needs to be in a livable condition, a place that's safe and healthy to live in. And California has detailed codes and regulations that really spell out these requirements.
So let's say a tenant is living in a unit that doesn't meet these basic standards. What can they do? What are their options?
The first step is to notify the landlord of the problem in writing and give them a reasonable amount of time to make those repairs.
And if the landlord kind of drags their feet or ignores the request altogether?
Then the tenant has a few different options. They can file a complaint with the local housing authority. They can withhold rent until the repairs are made. Or they can even break the lease and move out without penalty.
So they're not stuck in a dangerous or unhealthy living situation.
Not at all. California law gives tenants tools to enforce their right to habitable housing.
Okay, so if you're a tenant, and you're dealing with a serious issue in your unit, don't just suffer in silence. Document the problem, notify your landlord, and know that you have legal options. Now let's talk about another issue that's sometimes used as a tactic to pressure tenants: illegal utility shutoffs.
Yes, this is another big one. It's a tactic some landlords might try to use to force tenants out, but it's absolutely illegal in California.
So what exactly is an illegal utility shutoff?
It's when a landlord intentionally cuts off essential utilities, like water, electricity, or gas, to a tenant's unit.
And they can't do this for any reason. What if the tenant is behind on rent?
It's still illegal. California law specifically prohibits landlords from using utility shutoffs as a way to force tenants out.
So even if a tenant is struggling financially, they still have the right to those basic utilities.
Absolutely. Those utilities are essential for health and safety. They're considered a fundamental right.
Now, I'm guessing there might be some exceptions to this rule. What if there's a legitimate reason to shut off the utilities, like a safety hazard or a major repair?
You're right, there are some exceptions. If there's a genuine emergency like a gas leak or a burst pipe, the landlord might need to temporarily shut off utilities.
But even in those cases, they have to follow proper procedures.
Absolutely. They have to give the tenant proper notice, explain the reason for the shutoff, and make every effort to restore service as quickly as possible.
So it's not just a free pass for the landlord to interrupt those essential services.
Yeah.
What should a tenant do if they experience an illegal utility shutoff?
Document everything. Take pictures, keep records, and reach out to a tenants' rights organization or an attorney immediately. You have a legal right to have those utilities restored, and you might even be entitled to compensation for any losses that you've suffered.
Now let's shift gears slightly and talk about a topic that often comes up in the context of eviction: rent control.
Rent control. A hot button issue in California, especially in areas with high housing costs.
So for our listener, what exactly is rent control?
It's essentially a set of laws that limit how much a landlord can increase rent on certain rental units.
So it's designed to protect tenants from those huge rent hikes that we often see in competitive rental markets.
Exactly. It's a way to keep housing affordable and to prevent tenants from being priced out of their neighborhoods.
And rent control exists in various cities across California, right?
That's right. But it's not a statewide policy. Each city or county decides whether or not to implement rent control. So it can be a bit of a patchwork across the state.
So tenants need to find out whether or not their unit is covered by rent control.
Absolutely. It can make a huge difference in how much their rent can be increased. And it can also affect their rights in an eviction case.
Now, I'm guessing rent control laws can get pretty complex, with lots of details and variations.
You're right. The specifics can vary quite a bit depending on the city or county. It's always a good idea to consult with an expert to make sure you understand the rent control laws in your area.
So let's talk about how rent control ties into eviction. There's this term just cause eviction. What's that all about?
Just cause eviction is a key protection for tenants in rent-controlled units. It means that the landlord can't evict a tenant for any random reason. They need a legally valid justification.
So just giving a 30-day or 60-day notice and saying, time to go, isn't enough.
Not if the unit is under rent control. Landlords need to prove that they have a good reason to evict a tenant, a just cause.
Okay, what are some examples of those just causes? What are some reasons a landlord might be able to evict a tenant from a rent-controlled unit?
Well, non-payment of rent is always a valid reason. If a tenant consistently fails to pay rent, the landlord has grounds for eviction, regardless of rent control.
Yeah, that makes sense. What else?
Other valid reasons might include causing significant damage to the property, engaging in illegal activities, or violating the terms of the lease in a way that impacts the property or other tenants.
So things that are detrimental to the landlord's investment or the safety and well-being of other tenants.
Exactly. It's not about minor annoyances. It needs to be something substantial. And if a landlord tries to evict a tenant without just cause, the tenant has legal options. They can fight back and challenge that eviction.
And in many cities with rent control, there are special boards
that handle these kinds of disputes.
Oh, so they can kind of step in as a neutral third party?
Yeah.
And make sure everything's above board?
Exactly. It adds an extra layer of protection for tenants in those rent-controlled units.
Okay, so rent control and just cause eviction are really important concepts for tenants to understand, especially in those areas where rent control exists. Now let's talk about a specific type of eviction that's become kind of a hot-button issue in California, the Ellis Act eviction.
Ah, yes, the Ellis Act. This one can be a real curveball in the world of California evictions.
So what's the Ellis Act all about? How does it work?
It's a state law that allows landlords to evict tenants for the purpose of going out of business as landlords.
So they're basically saying, we're done being landlords, we're selling the property or converting it to some other use.
Exactly.
And under this law, they can evict tenants, even if those tenants haven't done anything wrong.
Unfortunately, yes. It's one of the very few situations where a landlord can evict without having to prove just cause. And it's definitely become a controversial issue, especially in areas where affordable housing is scarce.
So what are the rules and requirements for an Ellis Act eviction? What does the landlord have to do to make it legal?
Well, they have to give tenants proper notice. The length of that notice period depends on how long the tenant has lived in the unit.
So we're back to those familiar timelines.
Yeah.
30 days, 60 days, or even longer.
Exactly. And they have to follow those strict rules for proper notice delivery that we talked about earlier.
Okay, what else is required?
They have to be able to prove that they are genuinely going out of business as landlords. They can't just evict tenants and then turn around and rent those units out to someone else at a higher price.
So there are safeguards in place to prevent landlords from abusing this law.
Yes, there are definitely restrictions to prevent that kind of manipulation. And they also have to provide relocation assistance to tenants who are being evicted under the Ellis Act.
Relocation assistance. That sounds helpful. What does that typically involve?
It varies from city to city, but it usually includes some financial assistance to help tenants cover the costs of moving and finding new housing.
So it's not just you're out good luck. There's at least some effort to help those displaced tenants find a new place to live.
Exactly. It's not a perfect system, but it does provide some support.
Now, Ellis Act evictions seem kind of complicated with a lot of specific requirements and nuances.
Absolutely. It's always a good idea for both landlords and tenants to get legal advice if they're dealing with an Ellis Act eviction. There's a lot at stake.
Okay, so we've covered rent control, just cause evictions, the Ellis Act. Lots of important ground there. Now let's talk about a specific type of housing. That often has its own kind of unique set of rules. Mobile homes.
Yes, mobile homes. They represent kind of a unique segment of the housing market, and they often have their own specific laws and procedures when it comes to eviction.
So what are the key things to know about evictions in mobile home parks? What makes them different?
Well, for one thing, many mobile home parks in California are subject to rent control.
So those protections we talked about, just cause eviction limits on rent increases, those would apply to mobile homeowners as well.
Exactly. And this is crucial because many mobile homeowners are seniors or on fixed incomes, and they might be especially vulnerable to displacement if their rent were to skyrocket.
Even though they own their mobile homes, they're still renting the land underneath them.
Right. And that land rent can be a significant expense. Rent control helps keep those costs in check and protects those residents.
Now, are there any other special rules
Yeah.
that apply to mobile home evictions? Aside from rent control?
Yes, there are some specific procedures that landlords have to follow when evicting a mobile homeowner. For example, they have to offer the homeowner the right to sell the mobile home in place before going through the eviction process.
So it's like an extra step to try and help the homeowner avoid being displaced.
Exactly. It gives them an opportunity to recoup some of their investment and possibly stay in their community.
And if the homeowner can't sell the mobile home?
Then the landlord can proceed with the eviction. But they still have to follow all the other rules and procedures, proper notice, a court hearing. All of that still applies.
So it's a bit more complex
Yeah.
than evicting someone from a typical apartment.
Definitely. Those extra steps are there to protect the rights of mobile homeowners.
Okay, so mobile home evictions are a whole other area of expertise. Now we've covered an incredible amount of ground today, from the basics of notices to the complexities of rent control, just cause evictions, the Ellis Act, even mobile home evictions. It seems like tenant rights law in California is vast and ever-changing.
It definitely is. And that's why, continuous learning is so important for advocates like yourself.
So how can our listeners stay up to date on all the latest developments?
There are lots of great resources out there. Subscribe to legal newsletters, attend workshops, network with other tenant rights advocates.
Connecting with that community of advocates can be so valuable.
Absolutely. You can learn from each other's experiences, share strategies, and support each other in this really important work.
So as we wrap up this incredible deep dive, are there any final words of wisdom you want to leave our listener with?
Yeah.
Any parting thoughts for those who are fighting for tenant rights in California?
I'd say never underestimate the power of knowledge. The more you understand about California's eviction laws, the better equipped you'll be to advocate for your clients and to protect their rights. And remember, even though California's eviction process is, it's streamlined, tenants still have rights and options every step of the way.
So it's a fight worth fighting. It's about empowering tenants, making sure they know they're not alone and that they have legal options. Now, before we sign off, you mentioned earlier that local regulations can sometimes layer on top of state law, adding another layer of complexity to these cases. Can you give us some examples of how those local rules might impact evictions?
Absolutely. One common area where local rules can have a big impact is in the notice period. While state law sets minimum notice requirements, some cities or counties might have longer notice periods.
So a 30-day notice under state law might become a 60-day notice, or even longer depending on the city.
Exactly. It's crucial to check those local ordinances to make sure you're providing tenants with the correct amount of notice.
Okay. What other areas can be affected by local rules?
Another one is just cause eviction. We talked about how rent control often includes just cause provisions, but even in areas without rent control, some cities might have their own just cause ordinances that apply to all rental units.
So even if a unit isn't technically under rent control, a landlord might still need a valid reason, a just cause to evict a tenant.
That's right. These local ordinances can offer additional protections for tenants, so it's really important to be aware of them.
Are there any other examples where those local rules might come into play?
Relocation assistance is another one. We discussed how the Ellis Act requires relocation assistance in certain situations, but some cities have their own relocation assistance ordinances that might apply even broader.
So even in situations where the Ellis Act doesn't apply, tenants might still be entitled to financial assistance to help them relocate.
Exactly. Those local ordinances can make a real difference for tenants who are facing displacement.
Okay, so the key takeaway here is do your homework. Don't just assume that state law is the end of the story. Those local regulations can really have an impact on the outcome of a case.
Absolutely. Always check those local ordinances. They can be a game changer.
All right, it seems like we've explored just about every nook and cranny of California eviction law. We've talked about notices, timelines, service procedures, tenant rights, those tricky special cases, rent control, just cause eviction, the Ellis Act, mobile home evictions, even those all-important local regulations. I hope our listeners walking away from this deep dive feeling informed, empowered, and ready to advocate for those tenant rights.
I hope so too. Remember, knowledge is power, and you're making a real difference in people's lives by helping them navigate these challenging situations.
And to our listener, thank you for joining us on this deep dive into the world of California eviction law. We'll catch you next time on The Deep Dive, where we'll unpack another fascinating topic.
Call now 714-442-9741. Thank you.